This, you guys, is a really good and complicated question. If you have shared parental responsibility, then you are required to consult with and make parenting decisions together with the other co-parent for any major decision. I guess the question comes down to whether or not enrolling in this particular camp is a major decision. That's the first thing. The second thing is whether or not the camp is for childcare purposes, because if the camp is for childcare purposes, you are allowed to register the child in camp if it's reasonable and necessary in order for you to work. However, your parenting plan is going to dictate who is allowed to do the registration and who's allowed to decide the camp. Now, at the end of the day, if you're willing to pay for camp and you want to put the child in camp and it's not impacting the other parent's time sharing and it's not some sort of dangerous activity, there is no way in the world you're going to be denied the ability to do that by a judge. But the question as to whether you can do it over her objection is something that we would really have to look at your particular parenting plan to see how it's laid out, and then do an assessment of whether or not it really is a violation of shared parental responsibility. And if it is that something you're willing to risk under the circumstances?